Good afternoon, everyone. Thank you for your time. Thank you for joining us from all over the world, all over Africa, all over the US. We really do appreciate the time and the effort that it takes to join us. Unfortunately, my co-host John Ukebu has experienced quite a serious technical difficulty. We have tried to sort it out, but he will not be able to join us yet. I'm hoping that maybe something happens and he'll be able to join us a little bit later. But for now, I will be running the show. I'm just going to give a short, quick introduction, deal with some of the platform etiquette and how we're going to run things today. And then I will be handing over to AGA Africa Country Coordinator, Kim Robinson. So today's webinar is about platform liability. Now, platform liability has its origins in the UNCITRAL Model Law on Electronic Commerce, which was adopted way back in 1996. And that document established a framework for countries to enact laws that support electronic commerce. One of the key principles of the model law is that electronic intermediaries, such as online platforms, should not be held liable for the content that users post on their platforms. And this principle was expressed in Article 16 of the model law. And it was based on the idea that electronic intermediaries, such as platforms, should not be held liable for the actions of their users, as they are not the originators of the content and are merely providing a platform as hosts for others to share information. But we have come a long way since 1996, where huge platforms as they exist today didn't have the power or the technology that they do now. And so we're seeing a lot of arguments around this platform liability regime, which creates a liability shield that allows platforms to shirk the responsibility for the content that they host or transmit. And it contributes to the proliferation of harmful content, harmful practices, harmful commercial and fraudulent activities. And in response, in response to these concerns, some countries have started enacting or proposing new laws or using other legislation to hold online platforms more accountable for the content that they host or transmit. My apologies. And that is why we are having today's webinar, is to look at these issues, to consider the question of whether that liability shield should or should not stand, and taking in the various views around that. So it is my pleasure to hand over to Kim in about a minute. Just for the speakers, I am in charge of keeping you all to time, and I will be interrupting you. I will put on my camera when it's about 2 or 3 minutes left of your time to speak, and fairly shortly after your 20 or 25 minutes have lapsed, I will then interrupt you and ask you to please close off. All right, so if you see my camera go on, it will be probably about 2 or 3 minutes towards when you should be looking to wrap up. I know that time runs away when we get talking about things that interest us, things that we are passionate about. So those are just the clues, or the clues that you should be on the lookout for. So without further ado, let me hand over to Kim. Kim, are you with us? There we go.
Indeed, I am with you. Professor Papadopoulos, thank you so much for opening. Greetings, I am Kim Robinson. I am the country coordinator for Attorney General Alliance Africa based in Johannesburg. it is my job to welcome you and to thank you for your presence here. Mr. Stephen Cobb, the former Deputy Attorney General of the state of Virginia in the US, distinguished guests, ladies and gentlemen, on behalf of Karen White, the Executive Director of Attorney General Alliance, I welcome you to this webinar. Our webinar, Platform Liability in E-Commerce, Consumer Be Aware, the Wild World of E-Commerce. We present this in conjunction with the University of Pretoria, and we thank them for their longstanding and productive partnership. E-commerce is convenient, but e-commerce can also be dangerous. So those are some of the issues that we will be exploring today. And as is normal for Attorney General Alliance Africa, we are exploring this with people with academic expertise, but as well as practical and real life expertise in protecting consumers and looking at e-commerce issues. Also, we have our orientation is to make this a global conversation. So we have expertise from South Africa, expertise from the rest of Africa, from Mauritius, and expertise from the US. Attorney General Alliance, our mandate is to assist those people in the criminal justice value chain to fight cross-border crime. We can only do that effectively if we build skills and build relationships. And we do that by getting practitioners in the room, talking to one another, across borders, across oceans, even across specializations of work. So I'm looking forward to this conversation. Our co-host today, Professor Sylvia Papadopoulos, advocate and assistant professor in the Department of Mercantile Law at the University of Pretoria. Thank you for your time. John Okebu, who is with us in spirit, dealing with technical issues, senior staff attorney with the Northeast New Jersey Legal Services. Then our facilitators today, who will provide the content for the conversation today. From the US, Brandon Rutter, business and entertainment law attorney. From Mauritius, Michael AJ, an international business development specialist. And from South Africa, Jackie Fick, advocate and CEO of the company VizStrat Solutions. Again, with these perspectives, we will have a local, global, and African conversation. And again, thank you, Stephen, for your time. As former Deputy AG, you bring a perspective at a very senior and professional level, and we're looking forward to that context from you from that perspective. Again, I look forward to the conversation, and I encourage our participants online to engage actively. With that, I turn it over to former Deputy Attorney General Stephen Cobb. Thank you, Stephen.
Thanks so much, Kim. I think you almost gave me a promotion there to Attorney General, which I appreciate, but former Attorney General Mark Herring might have had something to say about. It's a pleasure to be with everyone today. I've had the distinct pleasure of being engaged and working with AGA and AGA Africa for many, many years since my time as Deputy Attorney General of the Commonwealth of Virginia, and through to now my experience in the private sector. It is such a rewarding organization. Last summer, I had the opportunity to be a guest of Nigeria's National Judicial Institute at their symposium in Abuja, and next month I look forward to Kenya's annual conference, which will be, I'm sure, another wonderful exchange. AJA's ability to convene thought leaders along with industry and government is increasingly valuable as we continue to confront new and legal regulatory challenges. It's more true today than ever in our world's history that we live in a global society, and what happens in Africa affects what happens in Europe, which affects what happens in North America, which affects what happens in Asia, and so forth, and so on, and vice versa. And it's because of opportunities like this for transcontinental dialogue and learning is more important and vital than ever. The more we learn from each other, the better prepared we are to address the challenges and ensure our collective greater successes. And this is in part why today's discussion on e-commerce and platform liability is both so important and so timely. When we look at e-commerce in a macro perspective, it's easy to forget how far this area has developed in the last 30 years. I know I'm dating myself, but in my youth, there was no such thing as e-commerce. I got clothes from the little shop next to my middle school, which was 2 blocks down from my church. We had a neighborhood grocery store for food and produce, so I went to the Sports Authority for athletic gear and Radio Shack for electronics. Maybe some of you share these similar memories. Now I'm part of a growing number of statistics as e-commerce continues to grow into an international juggernaut. So I want to set the stage a little bit to underline the importance of today's subject matter before we hear from experts from across Africa and the United States. When I served in the Obama administration, the Undersecretary of Commerce had a penchant for saying that in today's global economy, a new business's first sale could as easily be in Beijing as it could be in Boston. This is wonderful for the ability to open up new markets for large and small businesses alike, but it's not without its regulatory headaches, and businesses struggle with all of the risks associated with a growing e-commerce platform. But besides that, we see, regardless of those risks, e-commerce continues to grow and to grow. So let me share with you a couple statistics. According to Forbes, 20.8% of retail purchases are expected to take place online in 2023 and grow 10.4%. By 2026, 24% of retail purchases are expected to take place online. The global e-commerce market is expected to total $6.3 trillion. That's nearly twice as large as the GDP of the entire African continent. And by 2026, it's supposed to total 8.1 trillion, equal to nearly half of Europe's GDP today. The US e-commerce market alone will reach $1.1 trillion in sales in 2023. This is staggering. We see 79% of shoppers shop online once a month. 57% of online shoppers report shopping internationally. And so when we think about over half of all e-commerce being an international marketplace, it is dialogues like this when we talk about protections, when we talk about regulatory enforcement, and we talk about what is around the corner that makes these dialogues so very important. But e-commerce is more multifaceted than I think most average citizens and even maybe lawyers think about. The industry is more than just online retailers, and one of the ways that e-commerce has evolved, particularly over the last decade, is the use of social media and social media influencers in pushing products on consumers. Now, if we were all in the same room and out on a webinar, this is about the time I'd try and interact and show for a show of hands. For people who have accounts on Twitter or Facebook or Instagram or Snapchat or YouTube. But judging by the enrollment numbers, I think we can assume that most people on this webinar probably have at least one social media account. Well, nearly $1 billion, 992 billion, nearly $1 trillion was spent on social media commerce in 2020. Over the next 3 years, social media commerce is expected to reach nearly $3 trillion. In the US alone, 100 million people shop on social media. That's nearly a third of our population. 40% said they make purchases because of social media influencers. 49% of social commerce shoppers have had to influence from a social influencer's recommendation. Once again, I find myself part of the statistics. I've purchased products based on ads I saw on social media, as well as products I've seen endorsed by influencers. So the rules that govern platforms, the rules that govern social media, speech, content regulation are also going to have a very clear impact within the larger e-commerce ecosystem. But let's talk a little bit just from about how, when, and why many engage in e-commerce. And of course, social media isn't the only avenue. You see people interacting more and more with brand loyalty, with loyalty programs, with email solicitations, with banner ads. 64% of US consumers and 84% of millennials, generally those folks late 20s to mid-late 30s, are comfortable sharing their psychographic and behavioral data in return for better service. So in part, this is going to impact how we look at things like privacy, things like tracking, things like online cookies, and how they impact not just the bottom line for sales price, but in the larger regulatory agenda of e-commerce and regulatory enforcement. But when one industry is on the rise, that is often coupled with an increase in problems. And e-commerce is no different, especially in the areas of fraud. So let me give you a couple more statistics. $41 billion was lost to e-commerce fraud in 22. 48 billion is expected to be lost in 2023. So for where if it gets fraud, then you have a new market coming up of preventing fraud. And so e-commerce fraud and detection is going to create its own industry of over $28 billion in the United States alone, trying to balance and secure safety and security for online engagement, online commerce. And then what we've seen is governments from around the world starting to step in and fill that regulatory void. Since the advent of e-commerce, regulators across the globe have continued to balance the need for consumer protections with the risk of stifling innovation and market expansion. And regardless of when we talk about government involvement, this is usually the balance that we look to create. How do we promote innovation with protecting the consumer and the public? And as e-commerce is no different. And as it continues to go, regulators can hardly keep up, but they continue to try and find, and in fact, prioritize regulation and enforcement when it comes to e-commerce. As an aside, when we talk about platform liability, I know one of our speakers later today is going to talk about Section 230 of the Communications Decency Act in the United States. I had the privilege of arguing one of the first pieces of litigation in the United States Fourth Circuit on platform immunity under Section 230. And that was probably in 2009. But now we've, from what was one of the very first cases to now what we see is a huge area of case law. This is only going to continue to develop and develop. But to give you an idea of how far we've come, the Federal Trade Commission in the US brought its first enforcement action on e-commerce in September of 1994. By 1999, it had its 100th case to stop an internet scam. Now, I think that there is an unprecedented number of opportunities. The same agency has released data that consumers in the United States were losing $9 billion a year in online fraud. So what went from one enforcement action in 1994 to $9 billion of fraud and liability in 2023. That is exponential growth. As was alluded to earlier, most countries around the globe have found a legislative framework for consumer protection, and many have taken steps to cover online transactions. And in part, this has been delivered through regionalization of consumer law and policy, with coordination taking place to a greater and to a lesser extent between the EU and APEC and our African counterparts. And we've seen some progress here through the United Nations as well, particularly the Commission on International Trade Law, the United Nations Conference on Trade and Development, and the Organization for Economic Cooperation and Development. Civil society groups, including Consumers International and consumer groups worldwide, have continued to play an important role in this discussion as well. This is one of the largest growth areas in the world. It is going to take continued dialogue, effort, legislation, and engagement in order to try and even barely keep up. And we've certainly seen that a great deal in the United States, as both state and federal regulators, as well as legislators, have taken notice and doubled down on consumer protection within the e-commerce space. Just this year in New York, new legislation went into effect requiring businesses that sell gift cards to post certain notices warning of scams. The FTC announced it is investigating consumer sign-up and cancellation for product delivery services. State attorneys general and their federal counterparts have launched investigations into the use of artificial intelligence in online transactions, the use of automated systems, compliance with US safety standards, pharmaceutical advertisements and sales, data privacy, tracking cookies, the use of non-disclosure agreements, prohibiting negative reviews. The list goes on and on and on. And as we look across the e-commerce horizon, there are certain areas that we can be certain are ripe for both bad actors and government intervention. The use and oversight of algorithms and AI in particular remain at the forefront for regulators, both domestic and international. I've talked a lot, and so I want to talk just about a couple more things, which is that AGA has put forward a really wonderful program today. In addition to speakers covering platform liability, we have U.S. presenters covering, as I mentioned before, Section 230 of the Communications Decency Act, which, as a generally speaking, provides immunity for online computer services with respect to content moderation. But as you listen today, also think about the different types of e-commerce that exist and how some of the legal issues that we are discussing will impact these different areas. And so generally you have 4 areas of e-commerce: business to consumer, business to business, customer to customer, and customer to business. While there's going to be some overlap, there's also going to be some large differences in some of the areas of regulation and impact, depending on which type of e-commerce transaction we're referring to. But regardless of the specialty or the country that we're talking about, one thing is certain, and that's that e-commerce is going to continue to grow. And we will be well served to listen to each other's experiences, continue to share in our expertise, our successes, and our failures, so that we can be better prepared for the challenges that lie ahead. Thank you to AGA and AGA Africa for bringing this wonderful program together. And thank you for letting me share some thoughts. I hope that everyone enjoys the rest of today's webinar and this symposium. It's really a pleasure to be here with everybody. Thanks so much.
Thank you so much, Stephen. That was a fascinating. I love the statistics. It puts everything into such perspective, and it shows you that we've really, you know, since this idea of immunity arose in 1996, we have come a very long way, and the market dynamics are very different to what they were in 1996. Thank you so much. Thank you so much for your time. I'm going to hold over on questions until the question and answer session from the attendees, and move on to the further speakers that are hopefully ready and waiting. So next up on the program is Advocate Jackie Fick from South Africa, and my hometown of Pretoria. So Jackie, I'm going to hand over to you.
Thank you very much. Am I visible yet?
Your slides are visible. I don't see your camera. There we go. There we go. Afternoon, Jackie. Thank you for joining us. Thank you for your time. And I'm going to leave it up to you.
Thank you very much, Sylvia, and thank you so much for having me this afternoon. It brings back fond memories of the days when I was still in the what we call the Attorney General's office here, is the National Prosecuting Authority, where I was also a Deputy National Director of Public Prosecution. So it at least means that I'm in good company when it comes to catching crooks and gathering digital evidence. Let me just attempt quickly to share my screen again. There we go. Let's just see if it gives us problems. Is my screen visible?
Your screen is visible. It's on the notes pages though again.
Hold on. We now know which button to press.
Perfect. There you go. You're good to go.
Thank you very much. Ladies and gentlemen, what I would like to share with you today, and in the line of platform liability, I've decided to title my presentation The World Wide West, because we have actually gone into a full-blown war when it comes to what we are experiencing currently in the world of e-commerce, in the world of cybersecurity, in the world that we find ourselves, this global village that we call cyberspace. So what I would like to do today, and also speaking on platform liability, is of course through the lens of my personal experience. As I said, I was a prosecutor for 16.5 years. I work exclusively almost these days with the police to design their training programs on cybersecurity. I advise on cyber-related prosecutions, do their training program, so it's very fresh in my mind. And just to top things off for my sins, I am also the person that's currently drafting the cybersecurity bill for South Africa. And why these things are all relevant to today's discussion, ladies and gentlemen, is I always say that cybersecurity and cybercrime form two parts of the same coin. The one, the proactive things that we do, and cybercrime, when I have that malicious actor, something breaks and I can attribute that to the criminal activity, very important. And of course, their friend is data privacy. And you need that. You need that coin because it becomes the most valuable contribution that we can have in the purse of e-commerce. So the need for cyber-related legislation and regulation, and this coming from somebody now in the private sector, it still, ladies and gentlemen, underpins our effective e-commerce. And we cannot have trade without trust. If we cannot trust our platforms, if we cannot trust this digital environment that we find ourselves in, be it locally or be it internationally, we are going to have a slowdown or a slower uptake of trade. We will not in the real world walk into a business where everything seems dodgy. We would not feel comfortable in buying something from there because it's not a trusted environment. And the same thing applies when it comes to the world of platforms, when it comes to those platforms that create the shops that we find ourselves in when we shop online. The second thing is, if we look at our platforms and we look at liability, we also need to put those glasses on and look at it on whether we are creating a transparent and a fair environment for customers and businesses, or businesses with each other, to do trade. And it also implies, ladies and gentlemen, that measures that we put in place must also enable us to clamp down on illegal transactions. Companies go and spend millions to bring up their platforms. It takes one bad actor to go and break down confidence in a business to a lesser or to a higher degree. But all that effort can be undone because why? We lose the trust in that business. We need to understand that when we transact online, when we deal with these platforms, we don't regularly see the person like we would across a counter. So trust in the online abilities and the trust on that platform and the security that it offers becomes crucial. It also goes, as I said, on a local as well as an international level. It shows if we have good cyber-related legislation and regulation, it also shows that that country that I am dealing with also has a good cybersecurity posture. And currently, putting my glasses on from a legislative point of view on cybersecurity, it also stresses the value of this critical information infrastructure that we have within each country. And of course, all our big platforms deal with an underlying reliance on that critical information infrastructure. They need to rely on the up of, for example, an internet service provider or a mobile network operator that needs to provide them that ability to operate. And here I put my cowboy hat on again. It also is that ability to detect and react and respond and remediate cyber incidents. And of course, a cyber incident that turns into a cyber crime. We need that ability and we need the whodunit evidence to put those cyber criminals behind bars. South Africa has also had a big drive towards the protection of privacy and personal information, which we will see in the next slide when I talk a little bit about the position in South Africa. one of the things that I think is an overlying theme between all these different disciplines is, of course, sessions like we are having today. It is the sharing of knowledge, it's the sharing of skills, the pooling of knowledge, and it is an increasing need for training as well as awareness on things like platforms, but also the concepts that underpin, and with a specific focus here, of course, on the underpinning concepts of cybersecurity, crime, and data privacy. Now, South Africa has seen an online intermediations platform market inquiry by our Competition Commission. And I think, Sylvia, you might help me, but I think it's only the draft report that is ready and the draft report that has been circulated. But basically what we see there, ladies and gentlemen, is it's a wonderful step in the right direction. Being an advocate, somebody in the legal profession myself, we like facts. We like an inquiry into the who, the what, and the how of how things are going to be done. And what this inquiry does, ladies and gentlemen, it examines who are the role players in South Africa, who's the big online platforms, what is, from a competition perspective, what is the pricing issues that we have here, what is the ability of a customer to access these things. Interestingly enough, if we look at, for example, from a software perspective, mostly those things in South Africa are available from international platforms. But definitely a step in the right direction to start looking at what we have available in South Africa and how we could better regulate it from a Competition Commission perspective. Of course, there are other initiatives also going on, ladies and gentlemen, that would look at aspects that, for example, relate to your cybersecurity, to the impact that we have from a cyber crime perspective, and the ability to gather the necessary digital evidence to deal with these kind of incidents. And when I talk about digital evidence, ladies and gentlemen, I'm not just talking at it from a criminal prosecution perspective. Digital or electronic evidence is reliable information and evidence that we, for example, can use in management decisions, things that we can use in our audit queries, things that we can use in criminal proceedings, but it is sound information generated by our systems that can inform our business processes, that can inform our strategies, but also be available for us to present in criminal or civil proceedings when the need arises. Now, one of the first pieces of legislation that came into effect that still is partially, or let's just say it's still in its partial form that it was originally published in 2000 and, oh, I've made a mistake here. It's not 2022, ladies and gentlemen, it's 2002. So with the Electronic Communications and Transactions Act, of course, the first time I dealt with it was because it was our first real attempt to motivate and to set out cybercrime measures in South Africa, and to give us the tools to effectively deal with these type of offenses. But that has now since been repealed, a big part of this act, by, for example, the new Cybercrimes Act that came into partial operations in 2021. But what we find in this legislation is basically nothing else than this loosely referred term as a liability shield for platforms. It says that basically you don't really have a liability, and it strengthens that whole approach of, I'm just there, I'm just the pipe. It's, for me, it's just the shop. I don't need to have liability in terms of what people post on my on my platform, what kind of business transactions happens there. And I think from my tone of voice, ladies and gentlemen, you would probably infer that I am all for having a reform in this area, and probably influenced mostly by the fact that I deal with these types of fallouts on a regular basis, and that whodunit evidence and liability becomes a huge issue. So in this act also provides for your takedown notices and, interestingly enough, no general obligation to monitor. Now, the friend to that act, of course, is the Cybercrimes Act. And as I already referred to, we also have the Protection of Personal Information Act that we fondly refer to as POPIA. Now, with the Cybercrimes Act, a little bit more than just our cyber offenses, but also the regulations around how to interact on this digital stage in the exchange of evidence and information when it comes to cyber related types of crime, or when there is a need for digital evidence. Interestingly enough, here we start moving towards holding electronic communications service providers and financial institutions liable for the reporting of cyber criminal activities on their networks. And this electronic communication service provider is a very wide definition, ladies and gentlemen. It's not just my ISPs, not my mobile network operators, but also even private institutions that provide communication services that can, of course, be put there for the exchange of data messages. We also see here offenses that we term malicious communication, where there is liability now, where an electronic platform is actually used for the distribution of messages that incite harm and violence towards people, towards groups, also threats for damage, and also for images. And this is an interesting thing, unique in South Africa. There's only a few countries, I think, in the world that does it, but we deal with intimate images, the distribution, the disclosure thereof, and those images are both real and simulated images. So again, ladies and gentlemen, fitting into this whole platform argument of, yes, can I really say that it's just child pornography that we should be monitoring? I do think, ladies and gentlemen, that we are moving towards an area, especially in South Africa, where we need to start looking at things like deep packet inspection and not just saying, I have the pipe there and I don't care in what is transmitted inside that pipe. Two of the other pieces of legislation that has an impact also on today's presentation, ladies and gentlemen, is our Copyright and our Films and Publications Act. I deal with a number of writers in South Africa that are sitting with their hands in their hair for the simple reason that they have not even embarked on their marketing campaigns before, for example, their books are being pirated and are being distributed free of cost on Telegram groups. And they are really struggling at this stage to say, what are we doing? What can we do to help protect against this online and illegal distribution of their works of art, of their publications, and so forth? One of the other things I just want to mention, ladies and gentlemen, before I close, is what I call the double A's. So firstly, the algorithms. It's a bad day to be speaking to me about algorithms, because I had somebody target me on Facebook with a lot of very sensitive images, as well as where I was told that my business page is going to be taken over because it had some other content, of course, criminally related. And what did Facebook do? And said they came back with an automated message saying they've reviewed my post and they can't see anything wrong. Luckily, ladies and gentlemen, this happened this morning, so I've used up all my swear words before I'm addressing you. So yes, algorithms do help with the ease of use. Yes, they do automate a number of transactions, but we need to ask the questions, are those algorithms protecting the business? Are they really protecting the customers or the consumers that make use of that platform that uses algorithms? And my humble submission is, I don't always think that is what's happening, ladies and gentlemen. The other thing is this buzzword of artificial intelligence and chat GPT, and I don't know who else we're chatting to, and all the ethical questions that there is around that. Does it have a facilitating, enabling, or an impairing role on e-commerce? I also think, ladies and gentlemen, there it could pose problems, but I do foresee that there is a lot of value that we can do in using artificial intelligence to better the services that we do. But again, as I say, influence with the world that I come from, we should not be facilitating crime and creating a market, not for legitimate businesses, but for criminals to pose as legitimate businesses and be able to sail under the radar of an algorithm to continue with their bad practices. Some of the things that we're currently facing in South Africa is an absolute explosion in terms of online scams with classifieds and advertisements for goods and services that are never delivered. People are scammed out of their money. I think this was even worse in times of COVID and lockdown. And this is coming, ladies and gentlemen, from a lady that loves her online shopping. So I'm not one of those that that is opposed to online shopping. But it does, ladies and gentlemen, sometimes create that question of, if our platforms are not liable for anything, is it contributing towards this move that we want to translate into cyberspace, that we want to conduct almost everything that we do in cyberspace? So in summary, ladies and gentlemen, I stress once again that we need sessions like we are having today. We need research, we need education and awareness, and we need to put our heads together. We don't have to reinvent the wheel anymore. There is so much research and lessons to be learned from different countries that joining forces here can only benefit us in the long run. And as I said, I do think within the South African context, there's a need for us to review this platform liability and to find a better way of doing things. And also to think, when we wrote, for example, the ECT Act, there wasn't things like deep packet inspection that was required for law enforcement services. So a lot of the things that is there that's being used for other purposes can now with great success be applied to say, we cannot say we don't know and we're just a pipe anymore. And it's all about adaptability, ladies and gentlemen. I spoke at the World Trade Conference early in last week, and I think I was one of the only people that was excited about standards and about new legislation, because for me, that presupposes that we did our homework in coming up with that business standards, with international standards, and that it was well thought through. Why is this so important? Because it creates certainty. Everybody knows what their rights and also what their responsibilities is. I cannot stress the need for international cooperation, harmonization enough. And also, ladies and gentlemen, this is not just when it comes to e-commerce, but also our law enforcement and our ability to conduct more effective and more safe types of e-commerce. Know your business and know your customer. We all know about KYC, and it's not KFC, ladies and gentlemen, but we need to know our businesses. We need to know what we can offer, what are our limitations, what is our best business models, and then also what our customers are. And in that visibility also lies my favorite thing. We will be able to more effectively identify the people that are making it their business to steal from us, be it in real life or be it online. And that is it from me, ladies and gentlemen. If there's any questions, I think Sylvia said it will be at the end. And you are also most welcome if you have anything about the legislation that you want to share with the poor advocate. I would love that. Thank you.
Thank you very much, Jackie Fick. That was very informative. I just want to check. I think John Ukegbu has joined us or managed to join us on his phone. John, are you with us? Okay, I don't see anything, so hopefully he's with us. He can hear us probably. I'm not sure he can turn on a camera or speak to us. So without further ado, thank you very much, Jackie. We're going to move on to our speaker from Mauritius, Michael AJ, sorry, Michael AJ. You will be joining us from Mauritius. I believe you are in Mauritius. Yes, there we go. Thank you, Michael.
Thank you very much, Sylvia.
There we go.
And
I can see
thank
you. Great.
And thank you very much for Stephen and Jacqueline for giving us such an insightful overview of the platform liability, both in the US and Mauritius. Also, a very big thanks to AGA Africa for allowing me the opportunity to represent Orama Corporate Services in Mauritius on this platform. I say a big thanks to Christina Chengendu, the CEO of Orama Corporate Services, for empowering me to represent the company as well. And a special thanks to all our wonderful guests for taking time out of your busy schedule to join us today on this platform. My name is Michael Ajay, originally from Ghana, but I'm a resident of Mauritius, and I'm an international business development expert. I head the International Business Development Department at Orama Corporate Services, a management company licensed by the Financial Service Commission of Mauritius. They are the regulators of corporate entities. Liaising with clients in the government, we assist clients with company corporation processes, trust, fund administration services, as well as property acquisition in Mauritius, amongst others, with the objective of ensuring a sustainable business growth in a conducive and thriving environment such as Mauritius. My expertise is providing tailored investment solutions and strategic guidance to high net worth individuals and renowned financial institutions with experience in navigating diverse markets and forging strategic partnerships that enables me to drive business expansion and maximize profitability. Kind courtesy to AGA Africa, I'll be giving an overview of the platform liability regime in Mauritius. Mauritius is a small but powerful island nation in Africa, located in the Indian Ocean, and is known by many as a beautiful tourist destination with beautiful beaches. Indeed, Mauritius is also a very beautiful tourist destination, but is also a reputable international financial center and that offers great tax incentives. For example, it has no capital gains tax, no withholding tax, no capital on duty on issued capital, no foreign exchange control policies, confidentiality on company information, exchange liberalization, and free repatriation of profits and capital. It has a distinct advantage of being a treaty-based jurisdiction with a substantial network of treaties and double taxation avoidance agreement, thereby enhancing the image of the jurisdiction as an international tax planning and a springboard for companies to easily spread across Africa, thereby acquiring the title, the gateway to Africa. Mauritius has managed to set itself apart from the rest of the continent, especially when it comes to protection of citizens and enhancing the well-being of investors through well-thought government policies and regulatory measures, thanks to the pragmatic and competent leadership. It is no surprise that Mauritius has managed to consolidate several accolades and ranks first in many sectors, including the safest country in Africa, the #1 in Africa with regards to the ease of doing business, according to the World Bank report in 2020, a very compliant nation, listing in the whitelist of the Financial Action Task Force and the Organization for Economic Development Good Books. E-commerce in Mauritius has experienced significant growth in recent years, with more businesses and consumers embracing online shopping as a convenient way to buy and sell goods and services, and is increasingly gaining popularity. And this was also catapulted by the COVID-19 outbreak. For example, per the 2021 statistics, Mauritius Statistics Report, total digital revenues accounted for was about $135.1 million in 2020, with e-commerce generating the highest digital revenues in the same year. And with a relatively high internet penetration rate of 62% in the same year, 2020, and a global ranking of 87 in the internet penetration. The government of Mauritius recognizes the importance of regulating e-commerce to ensure consumer protection and has put in place several laws and regulations to govern online transactions. One of the prominent laws regulating e-commerce in Mauritius is the Electronic Transaction Act 2000, which gives legal sanctity to the use of digital signatures and digital certificates. The law provides a legal framework for electronic transactions and was enacted to promote the development of electronic commerce and facilitate confidence in electronic transactions. The Act establishes the legal validity for electronic contract and signatures and safeguards the rights and interests of consumers engaging in online transactions. The Consumer Protection Act 1991 also applies to e-commerce in Mauritius. This law aims to provide protection to consumers by regulating unfair trade practices. And also, it ensures that the consumers are informed, safe, and have the right to unfair treatment in transactions. Under this act, consumers are protected against false advertising, misleading pricing, unfair contract terms, and other deceptive practices. Additionally, the Data Protection Act 2017 has specific provisions related to e-commerce and the protection of personal data. This law outlines the rights and obligations of individuals and organizations when collecting, using, and disclosing personal information gathered through e-commerce transactions. It's worth mentioning that the government of Mauritius has initiated various programs and incentives to promote e-commerce and digital entrepreneurship, fostering the growth of the sector and creation of opportunities for businesses and consumers. These initiatives include the e-commerce support program, which provides financial assistance to small and medium-sized enterprises for the development of the e-commerce platform and the acquisition of digital tools. Regarding the platform liability regime in Mauritius, the platform liability regime in Mauritius is no different, and there are not just policies and laws in place, but institutions have been erected to ensure that the policies are well implemented and consumers are well protected while enhancing the investor interest. The Information and Communication Technology Act 2001, as amended in 2018, is the primary legislation that holds internet content providers responsible for the content they put on the internet. This act provides a legal framework for the regulation of information and communication technologies, including the online sphere. Under this act, the Information and Communication Technology Authority is established as the regulatory body responsible for overseeing and enforcing compliance with the law. The ICTA, has the mandate to monitor and regulate internet content here in Mauritius. They can take action against internet content providers who publish or distribute unlawful, harmful, or objectionable content. The ICTA has the authority to issue takedown notices, suspend or block access to specific content or websites, and impose penalties for non-compliance. Furthermore, the Computer Misuse and Cybercrime Act 2003, as amended in 2018, also governs certain aspects of internet content. This act criminalizes various cyber offenses, including the dissemination of racist, obscene, or defamatory materials through electronic systems. Internet content providers can be held accountable if they engage in such activities. It is important to also note that the ICTA, as the regulatory body, works closely with other relevant authorities here in Mauritius, such as the law enforcement agencies, to ensure compliance with the laws related to internet content. They cooperate with these entities to investigate and prosecute cases of illegal or harmful online content. Overall, the ICTA and the Information Communication Technologies Act, along with the Computer Misuse and Cyber Act, play a very crucial role in regulating and holding internet content providers, and also ensure that they are responsible for the content that they publish or distribute on the internet here in Mauritius. Ladies and gentlemen, there are some special key features in the Information and Communication Technologies Act 2001, as amended in 2018, that I want to take this opportunity to share with you. Now, this can be found in section 18, for example, in 18.1. Now, in section M, it tells you that the authority must take steps to regulate or curtail the harmful and illegal content on the internet and other information and communication services. Subsection N says that the authority must ensure the safety and the quality of every information and communication services, including telecommunication services. And for that purpose, determine the technical standards for telecommunication networks, the connection of consumer equipment to telecommunication networks. Or suggest that it must entertain complaints from consumers in relation to any information and communication services in Mauritius, and where necessary, refer them to the appropriate authorities. Now, one notable feature of the policy, which is very commendable to the Mauritius authorities here, is the online filtering system, for example, specifically the child sexual abuse online filtering system. Now, this is actually meant to ensure a safe digital environment for Mauritian children, and is one of the major commitments of the regulatory authority here in Mauritius to fight and prevent child sexual abuse online. It's a very good initiative from the Information and the Communication Technologies Authority for successfully being able to adopt such a solution. Now, it is very important to also note, and I will emphasize, that Mauritius was the first African country to implement such a centralized filtering solution to protect children from sexual abuse online. Now, the ICTA's SCA solution filters access to CSA sites for internet users in Mauritius, and this filtering mechanism is based on international partnerships and uses the method of blacklisting to prevent internet users in Mauritius to access the CSA materials. The objectives are in threefold. The first is to offer great protection against accidental viewing. The second is to reduce the availability and the circulation of CSA materials in Mauritius. And the third is to limit the trauma experienced by victims and their families. The ICTA's project on CSA materials filtering is also pursuant to the recommendations of the Budapest Convention on Cybercrime 2001 and the UN's Committee on the Rights of the Child. Article 9 of the Budapest Convention on Cybercrime 2001 specifies that each country shall establish measures to criminalize the offenses related to child pornography, in particular making available, distributing, or transmitting child pornography through the computer system. Consequently, there is a need to create a forward-looking and more flexible framework to enable the ICT authorities here in Mauritius to transform itself into a more resilient organization responsive to the numerous pressures for change that confront it in light of the conventions. Ladies and gentlemen, the ICTA also has an online consumer complaint system, which enables consumers to lodge complaints or appropriate queries about ICT services. The ICT consumers can create an account on the system, for example, and file their complaint or submit a query. Section 18 of the ICT Act 2001 sets out the function of the authority. And this section has a number of key provisions which pertain to consumer protection. Now, this includes, for example, subsection 18B talks about the economic and technical monitoring of the information and communication industry in accordance with recognized international standard practices, protocols, and having regard to the convergence of technology. 18F talks about the report in such a manner as may be required to the minister or to any other person or any matter that lies within its purview, such as the performance of public operators, the quality of consumer service, and consumer satisfaction measured against the best available international standards. I would also like to point some notable features of the Cybersecurity and Cyber Crime Act 2001 as it is in Mauritius. And for example, section 23 states that failure to moderate undesirable content. And subsection 1 it talks about, and it says, it shall be the responsibility of the administrator of an online account to moderate and control undesirable content that has been brought to his attention by an investigatory authority. Section 2, it says that any person who contravenes subsection 1 shall commit an offense and shall, on conviction, be liable to a fine not exceeding 1 million rupees and to a penal servitude for a term not exceeding 20 years. Now, for the purpose of this section, undesirable content includes any online content that is deceptive or inaccurate, posted with intent to defame, threaten, abuse, or mislead the public. Section B, it says threatens public health or public safety. Section C says threatens national security. And Section D, promotes racism. Ladies and gentlemen, I bring to you the end of my presentation on the legislation or the regime that Mauritius currently has in place when it comes to the platform liability. Thank you.
Thank you very much, Michael Ajay. Fascinating, and I'm glad to see, as I said, I suspected that a lot of legislation is counter to that hosting exemption, and it's very interesting to see some of the similarities that are being carried through between jurisdictions. And I have a particular question that I'd like to ask you, but I'll hold that for the question and answer session. Thank you very much.
Thank you.
All right. John, would you like to join us? Are you available yet?
Sylvia, can you hear me now?
There
Finally, the mysterious John. I apologize to all. I've been having technical difficulties joining the webinar. This is the second time in a row that this has happened. So I'm using my cell phone to participate. I thank everyone who's participating in this webinar, and I thank especially the speakers, and the presentations has been excellent. I'm learning a lot. Over to you, Sylvia.
Thanks, John, and I'm glad you could join us. All right. Well, next up on our program is Brandon Rutter, who will be giving us a USA perspective on Section 230, of the Communications Decency Act, and a general overview of some of the developments in the USA, which I think are relatively different to the developments that we've had here in Africa. So over to you, Brandon. Thank you for joining us.
Hello, everyone. Thank you for having me. It's my pleasure. As you'll see in my background, my cat just decided to jump into the video, so I apologize if she starts doing cat stuff as she hunts birds out the window. I am going to share my screen. I have a little slideshow put together. Can you just confirm that you can see this, right?
We can see that, yeah.
Excellent.
Are you going to put it onto slideshow?
Yep.
There we go. Perfect. Great. Thank you.
Great. Yeah, so before I get started, I just wanted to give a little background about myself. I am an attorney based in Jersey City, New Jersey, which is right across the river from Manhattan and New York City. My practice is half in entertainment law, mainly in the music industry. I am also a musician myself. I've been a musician my entire life, so it gives me some unique perspective into the industry. And now that I'm doing it from a lawyer perspective, really provides some light from the other side, from the creative side. Also, prior to becoming a lawyer, I worked in software. I was a product analyst and a project manager for a software company, a financial software company. And that gives me some unique insight into basically what goes on behind the scenes of software companies and online service providers and platforms and things like that. You really see how it all works behind the screen. All the various people, the engineers, the developers, the analysts that are involved in creating the platforms. And it kind of reminds you that we're all just people doing our jobs. doing the best we can in the vast majority of cases. And it's really up to our systems of government and our systems of laws to help define the rules and to help lead us as we go into this brave new world that is the internet and that is online distribution and e-commerce and all of that stuff. So without further ado, I'm going to get into my presentation. It is on section 230 of the Communications Decency Act and basically everything that goes into that and has gone on since. Just a couple of caveats. There are a lot of nuances to this area of law, which we don't have time to get into today. I'm going to kind of be painting in more of broad strokes to give an overview of how things are laid out and how things have evolved in the past 25 years or so. And the other caveat is this is largely US-based law. It may not apply directly to other countries around the world, but it does apply indirectly because many of the largest online companies are US-based companies. So they have to follow US laws, and they largely will set up their systems and their products to follow US laws. So even if the law doesn't apply directly where you're located, it really does apply if you start to use the platforms that we are going to be discussing. And I just wanted to kind of overall frame this as a balancing act, and it really is a balancing act that's kind of changing depending on the new companies, the new technologies, and the new use cases for these technologies. So it's really important to kind of think about that. There is no correct answer. There is no end-all be-all for solving these problems. It's something that necessarily has to evolve, and often very fast. So who are the players in this balancing act? You've got the service providers. These are the platforms, the big companies, your YouTubes, Facebooks, Google, Twitter, Reddit, TikTok, Instagram, and smaller versions of these that exist in more niche areas of the internet. Another group of players are the users. These are the customers of these platforms. They consume what's on there. They might download, they might post, they might share. They might create derivative works, create new versions of stuff that they find online. They might not have permission to do that. We'll get into that a little later. And the third big group of players are the creators. These are your copyright owners, your trademark owners, your brands, your companies that are creating products to be sold on the internet, musicians, photographers, artists, writers. These are the people that are, putting their heart and soul out onto the page and out onto the internet for the users to enjoy. So I think it's the kind of think through these issues from each of the perspectives of these players, and it'll kind of shed some light onto the difficult questions. So what's at stake? For the service providers, it's literally the entire business of the internet depends on this. The internet is based on it's a counting game. You want more downloads, more streams, more searches. You want more views of your videos, of your posts. The internet is built to reward more. So therefore, the platforms are built to incentivize more. They want as much as on their platforms as they possibly can allow. And you'll see this is where we kind of butt heads with the creators and with the rules that we like to follow. For the users want freedom to use the internet. The internet was designed as this like universal thing that isn't going to be governed by governments. It's for the people. It's a way to connect the people, to find who you want to find all around the world. That's largely still what users want, the freedom to post and share what they want when they want to. And then for the creators, what's at stake is the control, the protection, and the exploitation of their works. When you own a copyright, when you own a trademark, you have the exclusive right to utilize that copyright or that trademark. You can license the rights to other people. You can sell the rights to other people and other businesses, but initially you have sole exclusive power And as we'll see, this runs into challenges with the internet. Let's dive into each of the categories a little bit. So the service providers, like I said, the business of more. So why is this? Largely, it's because the internet no longer requires physical products. You don't have to print CDs. You don't have to print books. You don't have to print pictures and things to physically sell. So therefore, the production and the distribution costs are no longer nearly as high as they used to be. You can produce it digitally online. You can ship it out to the world, literally for pennies in a lot of cases. So that's the big change. So how do the companies need to monetize this? They don't charge users money often. I mean, sometimes they do. This is changing, but it becomes a counting game, right? It becomes they earn a fraction of a penny for each time. So that means they need to get to billions and billions of uses. This is where economies of scale comes in. By concentrating services to a small number of platforms, it becomes cheaper and easier for the users to find what they want. It also becomes cheaper and easier for the creators to get their work out there. That you only have to post it on YouTube or on Instagram in order to get it out to the world. That was not the case 25 years ago. That was often not the case 15 years ago. But the end all be all for the platforms is they don't want to be liable for what their users do. They're just the platform. They're just the intermediary. They're just giving the users the ability to put it out there. They don't want to be held liable for what the users are doing, often without them knowing. From the user's perspective, I put the phrase for better and for worse. They want the freedom to utilize the internet however they like, which is a very powerful tool for good and for bad. We share knowledge much more easier now than ever before, but we also share bad things much more easily than ever before. The user can also become the creator, or in the downside, they can become a pirate. They can steal creations without realizing. They can manipulate creations without having permission to do so. This is a dangerous thing, especially for the creators. And then finally, as we all know, the internet can be used for some very terrible things and often anonymously and difficult to track. So this, like I said, for better and for worse from the user's perspective. And then for the creators, heart and soul should equal control. This is their lifeblood. This is what the creators do. This is what they're meant to do. Who will protect the rights of the creators? Who's responsible for detecting and removing the bad actors? We want to get our work out into the world, but we also need control over how that work is used. And then ultimately, many creators want to earn some money off of their creations. How do we leverage that with the internet? How do we monetize things? So kind of think through these things from each of these perspectives. So what are we to do, particularly in the US? It really started with Section 230 of the Communications Decency Act back in 1996. It really set the rules for the digital game, defined the marketplace, and really created the digital industries that we know today. And just quickly think about how not long ago this was, 27 years ago. Think about how much has changed in 27 years. Also think about how hard and how long it is to create laws and to negotiate laws and how slowly that moves. And right there, you inherently have this battle between a hyper fast moving industry versus very slow lawmaking. The Digital Millennium Copyright Act, the DMCA from 1998, that handled copyright specifically and how to better handle it for the digital age. FOSTA SESTA was a group of laws from 2018 that removed some immunity that was given to providers from the Communications Decency Act. And then there's a variety of case law, court cases that have helped to refine and develop the rules over the years. So first, let's quickly discuss Section 230. It essentially created the modern internet marketplace. It provided the ability of these platforms and these service providers to do their counting game, to have more videos, more downloads, more posts. It gave them safe harbors so they won't necessarily be liable for the content that are created by their users. Now they have to follow some rules, and this gets into a question of are they creating content themselves? Are they merely distributing content? Are they publishing content? How do we view those differences? Again, the balancing act. It also created Good Samaritan provision to allow removal or moderation of bad materials. And this is where each company has their policies. They have their rules. You're allowed to post this. You're not allowed to post this. If you post this type of material, we have the ability to remove it, or we have the ability to shut down your account. Before Section 230, this could provide liability. It could provide free speech liability, could provide copyright liability. Section 230 allows them to do this. The service providers do need to take reasonable steps to remove or block access. We'll get into this more later with the DMCA, but this doesn't take the providers off the hook. They still have to moderate, they still have to take down things that are illegal, but the question becomes, how do they figure that out? Because if you're YouTube, there's literally billions and billions of videos. How can they keep track of this? Millions of videos are uploaded every day. How can they possibly moderate this effectively? We'll get into that. And then the question is publisher versus distributor. Historically, a publisher is aware of what they're publishing. So therefore, a publisher should be liable for what they're publishing. Whereas a book or a distributor, if you think of it like a bookstore that has 1,000 books, they might not necessarily know what they're selling. They might not have read everything that they're selling. So historically, we don't impose a lot of liability on distributors. That's a key difference to kind of think about. The DMCA, the Digital Millennium Copyright Act, this dives into copyright specifically and creates safe harbors for the providers, again, for infringement by their users. But what this does is this requires the platforms to take down or block access to infringing material after they receive a notice from the copyright holder. This is what's referred to as a notice and takedown. This has been a very effective tool for creators to monitor their work and utilize the platforms to protect themselves. But oftentimes the platforms might become too aggressive with the takedowns. They might take down things that aren't infringing or aren't illegal. And that becomes a challenge of getting them, if you're the owner and it's not illegal, getting them to put it back becomes a challenge. You get a lot of automated messages, as was mentioned earlier. You get a lot of these non-response responses that really hinder the ability for this to work. It also creates a safe harbor of liability when users claim that it's not infringing and putting it back online. So FOSTA SESTA, this specifically dealt with online sex trafficking and using online resources for sex trafficking, human trafficking that previously claimed immunity from Section 230. This is relatively recent, 2018, and it gained pretty widespread support throughout the US, but there are drawbacks. And one of the main drawbacks is by specifically carving this out of Section 230, it causes these industries to go into the dark web, go into the areas of the internet that are kind of a gray area. They don't necessarily follow the rules. It becomes harder to prosecute. It becomes harder to enforce against these dark web platforms. So yes, it's a great thing to guard against sex trafficking and things like that, but it's important to think about the consequences. And then there's case law. So the U.S. system of laws, it's kind of it's a building of rules based on lawsuits and cases. So I'm just mentioning three of the more important ones. So largely case law found in favor of the platforms. Largely case law finds that platforms are not liable. It's Section 230 creates a pretty broad umbrella of liability protection. Roommates.com case is one of the cases that goes the other way. The website roommates.com required users to select a gender and a race for their profile. But then what that allowed was the people that are looking for roommates to potentially discriminate based on gender and race. And that discrimination goes against fair housing laws and goes against laws that we want to protect against that discrimination. So this is one of the rare cases that was found against the platform. The platform was liable for proactively requiring this discrimination as opposed to just letting the users do it on their own. The two recent cases that one was just decided in the Supreme Court, one was Google was sent back down to the lower courts. These cases deal with the concept of aiding and abetting illegal acts. They both involve some form of terrorism that involved deaths and terrible things. And these acts were largely promoted and organized on internet platforms. And to take it further, these platforms use automated recommendation systems, algorithms, to push and nudge certain posts and certain things to certain users. And the question before the court was, do these algorithms qualify as aiding and abetting these terrorist acts? Should the platforms be held liable? In Twitter case, the court said, no, it doesn't count as aiding and abetting for the criminal act, but the court did not speak specifically to Section 230. It didn't say whether or not Section 230 applies. And then it also remanded the Google case back down to the courts to reassess. But it goes to show the courts don't want to mess with Section 230 because it literally, and this is one of those cases where like this is not an overstatement. Like if Section 230 goes away magically, the internet industry marketplace goes away. It has to change itself. It'll have a chilling effect on the entire industry, which is a multi-trillion-dollar industry. So it's very important that we think this through and are very intentional about how we modify things. So finally, I kind of want to look forward, kind of what's next with this. And these are just my speculations, and this is nothing to like take as legal advice or anything like that. But right now, these platforms, back in 1996, many of them didn't even exist. The ones that did were small upstarts. They literally did not have the capabilities and the resources to police their users and to police the content. Now you could argue they do. Now these companies are some of the biggest companies in the world with unlimited resources. They have more ability to police their content than before. They have more ability to automate the policing of content. Should we put more onus on them? It's very interesting now that we're seeing some layoffs and some downsizing in the tech industries. A lot of times the first people they fire are these moderators, are these like trust and like the people that they have to comply with Section 230. They're often the people that get fired first. So I could see us getting to a place where we need to force them to do more moderation. I don't know how that would work, but it could become the quote unquote slippery slope that leads to this. What happens with the algorithms that nudge consumers? How strong of a nudge is too strong? We are very good at capturing data from consumers without them realizing that we're capturing it, and then using that data to push them in a certain direction. When does that become quote unquote publishing, or when does that become a hands-on approach from the platform? This is up for debate. How do we handle generative AI? What happens when the platform is the distributor? It's also the publisher. It's deciding what to publish. It's also the creator. It's creating new works all at once, all without direct input from people. This is very much becoming the case very quickly with generative AI. And this creates some very interesting challenges and problems that we need to solve. from the creative perspective, how do we guard against AI creating things based off of our works that we don't want it to create? Or perhaps we do. Perhaps we want to incentivize this. Very much a new question that needs to be solved. And then just largely, should we pare back Section 230 as a whole? Should we continue to just create specific carve-outs, against sex trafficking, against AI perhaps? That's a large question that I think we as a society really need to answer. And we really need to decide, where that goes. And if I still have some time, just a couple minutes, Sylvia, do I? Great. So I just wanted to dive into actually like seeing this in practice and how this works from the user's perspective. So here I am on YouTube. I'm not signed in. This is just the generic YouTube page. If you click the three dots, you see these options. These options would typically appear here if you are signed in. So then down the bottom, you can see the send feedback option. And then if you click send feedback, if you read the fine print down here, you see some policies, and then you see this legal help. Go to legal help to ask for content changes for legal reasons. So this gets into Section 230. This gets into the DMCA takedowns. And this is where you'll see YouTube has their own policies. So this gets into the Good Samaritan carve-outs. This is where YouTube creates its own community guidelines and privacy guidelines. And this is YouTube defining as a private actor, as a private entity, defining how it wants users to use its service, and will let you know what you can and can't post. This is all outside of the law. This is strictly a civil private thing. But down here you have the legal violations, and this is where you can do your takedowns. So with copyright, if you think someone is using your copyright illegally, you can submit a request to have them take it down. It gives you instructions on how to do it. And this is all part of the laws. The laws require that this is a straightforward, easy to use process. If not, YouTube would be in violation of Section 230 and of the DMCA. And as you can see, we have similar laws for trademark violations, counterfeit violations, defamation, other types of legal complaints. So yeah, if you're a creator, especially, I think you should get into this, learn about this for the different platforms, learn how to enforce your rights, and how to, use the platforms, to your benefit, because a single creator, it is not feasible to go out and police all these platforms. Like I said, millions, billions of videos. It's not possible. We have to use the platforms. We have to rely on the platforms to doing the policing for us. And these are the mechanisms we have in place. The question now becomes, how do we enforce the mechanisms, and how do we evolve the mechanisms looking forward into this, hyper growth, hyper speed industry? How do we handle it moving forward? Yeah, that's about it. I hope I didn't move too fast and try to cover too much, but I think it's kind of important to kind of set that high level background.
Thank you very much, Brandon. No, it was fascinating, and that is, I think, the heart of these webinars is just to get these different perspectives, different approaches, and see what we can learn and the insights that we can gain from one another. So thank you. No, it was perfect. Thank you very much.
Absolutely.
All right, I'm going to ask each of the speakers if they don't mind putting on their cameras again. And then to the audience, if there are any questions that you would like to present to the speakers, then please type those into the chat. I will then read them out to the speakers. But while we're waiting for the attendees to come up with some questions and to type them into the chat, I will start off the conversation. And my first question will be posed to Michael and to Jackie. And it's just, are you aware of any cases? I'm not aware of any, but I mean, I'm not an expert on this, but any cases where those safe harbors that are present in electronic communications type legislation, those safe harbors are pretty broadly defined. They were based on the model law. Have we used that as a defense, for example, to platforms being held liable for something in any of our African jurisdictions that we're aware of? Jackie, would you like to grab the mic first?
I'll indeed do so. Not that I can think of off the cuff. I know it is a very convenient excuse, this whole thing about saying, I just supply the pipe, and therefore thou shalt not hold me liable. What is interesting within a telco environment, however, if it comes to law enforcement support and you couple it with interception, that move of just listening to tring stuff is over now. We are looking at creating that deep packet inspection, DPI type of capability, because everybody these days is doing everything online. So yeah, it's very interesting, but I can quickly, Google is my friend. I can quickly look for some South African cases on that.
I'm not aware of any cases, but you know, there are many carve-outs. So for example, you've got data protection, you've got copyright, we've got cybercrime, we've got a whole, you know, the Films and Publications Act also carves out certain content. So at the end of the day, I'm just beginning to wonder what actually hosting protects, because there's a lot of content that is not protected, that is carved out. And is there any point in retaining that, for example, in South Africa's ECT Act?
Sylvia, I imagine that second part of the question is also coming my way, because otherwise poor Michael will have to go and quickly Google the ECT Act. That to me is the big thing with the ECT Act. Besides that, most African countries that I deal with have thought that our ECT Act is very nice. But the ECT Act has now in bits and pieces received plastic surgery. And bits and pieces of it has now been incorporated in new pieces of legislation. Yet this platform liability in terms of your hosting, your caching, everything is still there. We've seen the need to revise so much of this, but yet I foresee, not just from a criminal law perspective, but from a civil liability, if we look at the malicious communication type of offences, where a person can now be held liable for distributing messages that can incite harm to another individual, that can incite or can threaten a person. I can threaten you, Sylvia, online and say that you, your cats and your dogs are going to disappear from the earth. I can do those things online now. So that right of absolute speech, those were our biggest arguments in Parliament, is yes, I have the right to say whatever I want. No. Online, you also do not have the right to commit crime. And if we look at that and we go and we say, okay, I'm holding the person liable that used this platform to go and threaten me, I can foresee very soon, and sooner than later, that we are going to be looking at civil type of litigation, where people say, but you provided that pipe. You enabled them. Your algorithms, like in my case, I notified you that something was wrong, but you decided not to come to the aid of your customer. Now, we are definitely moving in South Africa towards those things. And I'm not saying it because I'm not a member of the bar anymore. So no financial benefit in me taking on mass court cases. So yes, I'd love to hear what Mauritius's problems are.
Well,
Thanks.
thank you
So
very much, Jacqueline.
Yeah, let me direct it to you then, Michael. Are you aware of any, where those safe harbors have been used to defend some of these carve-outs or in conflict with these carve-outs?
Well, I'm not aware of any specific case, but for what I know, with Mauritius being very, very prudent in regards to the legislations and protection of consumers or their customer. Protection of consumers. I know that they are very specific with the laws that are in place. So, for example, if you, like I said, if you look at the Cybersecurity Act 2001, and the Cybercrime Act 2001, they're specific on the provisions that are in the law. And if you go against them, then you obviously have to face, the law. Like I mentioned, there's no specific case that I can just pinpoint out right now, currently on the webinar. I might also have to do some research on this to be able to provide. But if you look at Section 16, for example, of the Cybersecurity Act, you see that it says, for example, the misuse of fake profile as an example. It says any person who individually or with other persons makes use of a fake profile to cause harm shall commit an offense and shall, on conviction, be liable to a fine not exceeding 1 million rupees or to a penal servitude of a term not exceeding 20 years. Section 17 speaks of cyberbullying. Section 18 talks about cyber extortion. 19 is on revenge pornography. 20 is on cyber terrorism. The laws are well defined. So what I know is that once you commit the offense, the system is actually being filtered and is being monitored. They're very proactive on that. Mauritius is very proactive when it comes to this. So once you are caught or you're within the purview of the law, what's for sure is you will face the law. In that regard, I think that cyber security or cyber crime here in Mauritius is, it's been properly regulated. It's been controlled. The word controlled. That's what I could say for now in regards to the question. As to a specific case, I'm not sure. At the moment, I can't pick one off my head right now.
Thanks a million, Michael. Over to you, Brandon. You asked on your last slide, are platforms liable for what their algorithms do? And I think, it also, AI is just a very fancy form of algorithm. But so what we're seeing in algorithms and regulating algorithms is definitely a very big push towards fairness and transparency around the world, a very big clampdown, especially on algorithms, AI algorithms for that matter. Do you foresee a time when the US will relook at 230? Is that time pushing harder if you're looking at regulating AI, regulating algorithms? Some of your platforms have received very large fines from the FTC that I'm aware of. So I think you're seeing a lot of pressure on platforms, and maybe that will bring about a little bit of reform, or maybe outward pressure onto changing that section 230.
Yeah, so in recent years, there's been a push for legislation that creates a licensing system, like a licensing and auditing system for companies, where basically, in order to qualify for Section 230 immunity, you have to get audited by the FTC or whatever body it is, And then as long as you prove that you're actually following the rules, then they'll grant you immunity. That's been a push in, I think it first started in like 2018, I want to say, and it's been it has bipartisan support on both sides, and I think it does make sense from a lot of regards, but my biggest concern with that sort of a scheme is it really protects the big companies. It protects because they can afford to actually get the light and do things right, right? Like your YouTube, yeah, okay, it might cost them, $10 million, but that's pocket change to them. But what about the upstarts? What about the small companies that, they might not have these funds. They might not have the expertise. They might not even understand the laws. They're just, some, tech guys in a garage, trying to create the new platform, right? They think they're doing it for the good of humanity. And by and large, that's what most tech companies start out as. It's like, we're doing this not for us. We're doing this for everybody, right? And then it evolves into this, okay, maybe it's not as good as it seemed. So that is one development that has been gaining steam. There are pros and cons, and I think it's similar to the data privacy laws. So I do a lot of work with a data company that operates internationally. So I have to deal with the GDPR and the how that changes in Europe and various laws in like Brazil and in California. It's like we're creating kind of this like license. It's almost a license. It's not licensing, but it's the same kind of idea where like you can get audited and you have to prove that you're following the rules, and it's very expensive. Lawyers, very expensive. It's very expensive to actually comply with these rules if they become too onerous. And you see that between Europe and the US, a lot of e-commerce companies, they don't want to do business in Europe because they don't want to spend the money to comply with the law. So you can see that's a real world example of kind of the chilling effects that these types of regulations can have on entire industries. And these are not small industries. These are arguably the biggest industries in the world right now. So it's very important that we are forward thinking and involve the businesses when coming up with these rules, because it's just or else everything could come crumbling down, honestly.
Thanks a million. I have a comment here in the chat. Kim has asked me just to comment and share. And she says that she's noticed a few themes that have emerged from this webinar. The first is that e-commerce is prevalent, it's growing and global, and as a result, having conversations where we share and can work on creating solutions is essential. And then she just says she would like to build on what Jackie said. Let's not reinvent the wheel, let's join forces and find those commonalities and ways forward. I do see, if you look to Europe, which is a very strict regulatory system, often in conflict with the US, more of a freer market regulated kind of a system. Europe is debating the viability of GDPR and mainly on the enforcement end of things. But they've also, they've had a whole string of legislation. So they've had the Digital Services Directive or regulation, I'm not sure which format it's taken, which is directed at large platforms and ensuring their liability for certain things. So they've more or less done away with that kind of liability shield. If you look at their AI regulation, which has been recently signed, it's also dealing with this fairness, this transparency, this open and access to algorithms. It's going to be interesting to see. It's the first piece of really definitive AI regulation that we've seen in the world. So it's going to be interesting to see how these, sort of Section 230 pipe exemptions are going to be affected by these carve-outs, because I think you're having a definite clash of ideals or principles behind these different pieces of legislation. All right, I don't see any other questions in the
Could
chat.
I just comment, Sylvia, and ask
Go ahead, John.
the participants, or the presenters rather, here in the United States, the Federal Trade Commission just brought an action against Amazon for a practice over here that's that we call dark patterns, where Amazon would get you to subscribe to be a Prime user under their program, and then once you decided that you wanted to no longer be a Prime account holder under the Amazon platform, it would literally make it impossible for you to opt out of the program. And I looked at the FTC complaint that was filed. It was over close to 150 pages, a lot of redaction. But I know Jackie had talked about AI and algorithms, and I would just like to get the presenters' thoughts on platforms that basically are using very deceptive means in order to retain users or people that patronize the platform, and what your thoughts are. Thank you.
I can jump in there. So from my view, a for-profit business in the U.S. has one job, and that's to make a profit. That is how it's been for the past 50 plus years since Milton Friedman, and that is how the market works in the U.S. And the Amazon example is just another example. Is companies will go as far as they can to make a profit until they're told otherwise. And then that's the default. And we would be kidding ourselves to think that it doesn't work like that, because that's how it works. So it becomes a game of whack-a-mole. And I apologize if people around the world don't know what whack-a-mole is. It's this game where these little moles, you hit one and then another one pops up, and you hit one and then another one pops up. That's what, if we're going to enforce things via the FTC or consent decrees, antitrust law, stuff like that, we have to think holistically, or else they will just find another way to do the same thing. And speaking to deceptive practices, I would argue most of the internet economy is based on deception. It's free. Oh, it doesn't cost any money. Oh, well, it's not free. We're gathering data. We're using data to build a profile of you. We're selling that data to other companies. We don't tell you that. That's been going on for decades, and we're now just wrapping our heads around that. So deception is what's the term? It's a feature, not a bug. Deception is a feature of the internet economy. And I would take it one step further. Social media, right? We hear so much about how addictive it is, about how damaging it is to mental health, especially with kids and teenagers. What else? What other industry is damaging and addictive? Oh, the tobacco industry. How many years, how many decades did the tobacco industry sell cigarettes saying there is no downside, it's not addictive, there's no problems, go ahead, smoke? And then it took us, the people, and it took the governments to realize, oh, hey, something is actually going on here. We need to step in and say enough's enough. You're deceiving the public. you're not informing us of the downsides of what you're selling to us. It's up to the government, and that largely worked with the tobacco industry, at least in the U.S. You know, different around the world, but the tobacco industry is a fraction of what it used to be, largely because of that effort. I think you can take parallels from that and apply it to the internet and online landscapes. A lot of it is deception, and a lot of it comes down to the users mobilizing and forcing governments to step in and put a stop to that deception.
I would just like to add that I was actually a victim of Amazon's Prime accounts charade, if I can describe it that way, because they attempted to enroll me in Prime, and then they claimed every time I go to purchase that my Prime account had been suspended, even though I was using gift cards to make my purchases. That's just on a personal note. So I endorse the FTC's action, needless to say. And I do agree with you, Brandon. It seems to be just the cost of doing business.
I mean, can I share?
Yes, please, Michael and Jackie, your thoughts, please.
Thank you very much. I think that in regards to just like Brandon mentioned, business owners will always be business owners. They would look for opportunities to maximize profitability in any ways. If there's no eyes on them, if there's no regulatory authority monitoring them, you know, so, unfortunately, not everybody has morals, you know, and some will go to any extent, even the cost of, at the cost of lives, at the cost of anything that stands their way. So I think it's very important that the regulatory authorities, the government, you know, sets up institutions, law enforcement agencies that can track and keep their eyes basically on trends, industry trends, and things that, you know, are always going on. Because without your eyes, without the knowledge and experience, expertise, and your eyes and ears on the ground, I mean, there's always going to be lots of victims before it comes to the awareness of the authority. You understand? And this is something that I think Mauritius is doing very, very, very well, because they're very, very pragmatic, and they're always, cyber crimes, they always try to be 1 or 2 steps ahead of, you know, of the authorities. But there has to be also an advancement in terms of what the authorities are able to do. You can't just sit down and let them always beat you. If they move to the left, you have to always try to move to the left and try to block them and frustrate them as much as possible. So for me personally, I commend, for example, the Mauritian authorities for, you know, being able to establish some of these institutions like the Information and Communication Technology Authority, for example, and their main focus is to ensure that they are, you know, monitoring, and they are frustrating, and they are, you know, creating the platform for people to, for consumers to be able to report, you know, suspicions and complain about, some of these things that's ongoing. Because if you don't create the platform for people to be able to complain, you know, then what's going to happen is there's going to be a backlog of complaints, which the authority basically has nothing to do about it, you know. So it's very important and it's very crucial that the authorities are always doing what's important, and also work with other international agencies in different jurisdictions and countries to learn what experiences has been going on, what trends are happening there, and then they can actually also put together measures and not wait for such such events to occur to them. So this is what I could say about such incidences. But yeah, it's very, very important that there are measures in place to secure. But ultimately, like I mentioned again, and I always say this, it boils down to the regulatory authorities. These are the main guys in place to ensure that if there's anything to be done, policies or enforcement, it boils down to these authorities. This is what I could say.
Jackie, I just to follow up on what Michael is saying. Mauritius and South Africa, obviously, they're better funded jurisdictions than most African countries. What are your thoughts on a more unified approach in Africa? First of all, I know I was just reading last week that I believe the Malibu Convention finally got ratified. In terms of pooling resources, because there's some numerous that let's say the majority of African countries, they don't have the resources, let's be honest, to regulate, enforce these laws. What are your thoughts, and what do you think leaders like South Africa and Mauritius and maybe one or two other jurisdictions in Africa can do in order to unify and pull the entire continent to where it needs to be? Thank you.
Thank you very much. And you see, this is a perfect question for me because Mauritius is my favorite country in the world. It's my soul place. So the interesting thing is, if we look from a from an African perspective, Mauritius was always in the forefront because they were the country that implemented the Budapest Convention with the most success, talking from an African perspective. And if you look at the South African legislation, as I said, with our Electronic Communications and Transactions Act, it's very interesting because I lecture quite a lot in Africa to see remnants of this legislation. For example, in the Malawi legislation, looking at Kenya, that's also very strong. So facilitating, for example, an effort here through a body like the AU, I think there's definitely a lot to be done. For the greater part, I think Africa is still seen as developing. I'd say it's not developing, it's opportunities to learn and to improve. And this is why, for me, it's so important to say that we don't have to reinvent the wheel. There is things that we can build on. But this one, I want to now bleed into answering your other questions. The importance for me with legislation and regulations, firstly, as I said again, is that whole process of consultation, that when we get to the point that we have legislation and we have standards and regulation, at least people have been able to give their input. And in that sense, it does create some form of certainty. It is the same as developing fraud management programs for a business. If you want to make it complex, people will find ways on not to comply with it. So the more complex, the more onerous things are, the more people by their very nature are going to find ways around it. I think that is just the way that we were put together. And for me, that balance is one of crucial importance. Brandon, I always talk about playing a game of chess, not just hitting the mole on the head, because I'll be accused of violence the many times I want to hit moles on the head. But for me, that whole thing it's true. We put something in place and somebody else will find a reason not to comply with it, to the point that you actually want to say they will face administrative penalties. They stop just short of you putting them in pink furry cuffs. They stop just short of criminal conduct. So a big balancing act there, but and I think from a personal point of view, I've seen this in drafting legislation now as well. in compiling things like the standard operating procedures for digital evidence in South Africa. If you make it in people's interest, if they understand your process and if they understand where you're coming from, it does help a little bit. And pushing the boundaries, as I said, yes, they definitely do. One of the things that we have in South Africa, and I say it with a caveat before I have to immigrate to Mauritius, but one of the things is we have wonderful laws. We have absolutely brilliant pieces of legislation, but that legislation is not worth the paper it is written on if we do not have continuous and effective implementation thereof. And that, when it comes to technology, plays into having governance level buy-in into your processes and having the people, the processes and technology available to make this work. You cannot fight technology and technology related crimes without having the technological backing for the people that are supposed to enforce this. Thank you.
Thank you very much, Jacqueline. I'm very excited that you are looking to relocate to Mauritius, and I hope to meet you in person as well. I like from listen. I'm a proud African, but I'm also sometimes mostly disappointed in the way things are handled in Africa, frankly. And I think Africa somehow has leadership problems. And these leadership problems, if not addressed, I think we should hit the nail on the head. A lot of times we like to sugarcoat things, and we like to say things because we obviously are either afraid, intimidated, or somehow unable to communicate to the leaders. But I mean, along the line, I've begun to see a few of these things coming together where we have leadership, leaders sitting together and begin to question themselves. And the same issue boils across, it goes across different sectors, not just the, not just on the online liability as well, but it's different sectors. If you look at the issue as to whether does Africa has the money, I mean, to implement such measures, I do think that it boils down to leadership problems, because I have a different perspective on the issues with Africa. Africa is not a poor country; it's a very rich country. We just have leaders who are not putting the right measures in place. And I mean, we can all decide to play the life of the ostrich, you know, and bury our heads in the sand and pretend as if we don't know what's going on. But we know the issues happening in Africa, and it's affecting my generation. You know, if the leaderships don't begin to put in place, if they don't show commitment, you know, it's always going to boil down to, you know, private organizations and individuals who have to put together conferences, webinars like this, and put together, you know, I mean, thanks to AGA for organizing such events. More of these things are necessary and needed in Africa, but the leaders themselves must take the mantle and initiate commitment. Otherwise, you know, Africa is very good in initiating policies. We're good at sitting down and talking about policies and this and that. But just like Jacqueline mentioned, when it comes to implementation, there's always that problem. They sit back, they're laid back. The laws are not enforced. The leaders will, and it's like a ring. The leaders themselves are part of it. They know what's going on. They brush it under the carpet. This is my nephew, this is my cousin, nepotism, whatever you call it. And so what? That's what happens. I think the African leaders need to sit up and decide. And some of them are beginning to do it. I mean, I'm not going to mention any leaders' name, but there are certain countries in Africa who have leaders who are showing that level of commitment, you know, in their countries. But Africa needs to unite. Look, there are certain things that happens in Africa that I personally don't understand. For example, it's very easier for a Russian to go to South Africa than a Ghanaian to go to South Africa. If you ask me, these kind of policies don't make sense, frankly. Like, come on. But we say we want Africa to unite, and we have different organizations sitting down talking about the unity of Africa. If Africa does not unite, then we don't trade amongst ourselves. If we are not able to move freely amongst ourselves, how do we improve infrastructural development? If you ask me to speak freely, I'm afraid some people might send assassins to come and take me out from this platform. I'm just gonna say this, but I think African leaders, quite frankly, are not taking Africa them serious. I mean, if you don't take yourself serious, you don't expect other nations or other continents to take you seriously. And sometimes I fear for the future of Africa. And you have certain countries in Africa who have taken cybercrime to be a means of survival, you know. And just off, I'm from West Africa. That's where I'm from. So I know people, I know fathers who take their children and take them to internet cafes and tell these people who are sitting behind computers and tell them, teach my son how to what? Utilize the computer to make money. They don't want to go to school. It's become a norm. Like these things, I don't know if there's any platform that captures some of these things. We call them the Yahoo boys. You know, we call them you know what I'm saying? They are learning. There are people who rent apartments and they sit down, they employ, they recruit people and teach them cyber fraud. So while you are busy making your money, doing your decent life, there are people seated, trained to come and attack you. This is ongoing, but what's really being done about it? You think the leaders are not aware? They are aware, but they are just as always. Excuse me. They move slow, and before they react, before they put any measures in place, it's too late. The continent is attracting bad names. This is pushing investors away. They're afraid to do business with the continent. Yet we are looking to develop the continent. So I think there should be more private, you know, organizations like this sitting together, talking about it, because if the government is not going to do it, we can also say we're not going to do it. So I appreciate when I see initiatives like what AGA Africa is doing, you know, putting initiatives together, putting people together, educating the public. We need to push it because the consequences, I mean, are there for us to face. And African leaders, I'll take an opportunity to tell them to step up. They literally have to step up the game, frankly. Yeah. Thank you.
Michael, I share a lot of your sentiments, but to counterbalance, you know, I mean, there's a lot of unscrupulous internet characters from Eastern Europe, for instance. So there are a lot of brilliant young Africans who in the cyber sphere who are doing wonderful things, creating platforms that are user friendly, that meet the local needs of their various jurisdictions in which they're located. So I'm not as pessimistic as you may sound. I just, you know, I share your sentiment that, you know, especially for the youth, that government should be an enabler, enable them to be creative, enable them to contribute to the society. And I'm a strong believer in capitalism. That's why I'm sitting here. But I also believe that there has to be rules of the road in any market-driven society. So that's the gospel according to John for today.
Thanks,
Thank you very
John.
much.
I just want to see if there are any questions from the audience, if there is anything else. I see Kim. Kim, would you like to speak now, or will you have your say when I hand over to you in a second or so?
I can speak when you hand it over to me. No problem. Thank you so much, Sylvia.
All right. Thanks a lot, Kim. Thank you. I see we're running down and we've kept nicely to time. So thank you very much to your to the speakers. It's been fascinating. It's been interesting. I don't have time, but the one question I wanted to ask you is, consumer protection is something that is a growing field. It's new for us. It's new in a lot of jurisdictions. But I was just wondering, Brandon's slide on are platforms liable for what their algorithms do, and I'm wondering when product liability is going to come into this question, because that is a very interesting field, and it has a lot of possibilities. But I'll leave it as a rhetorical question for now, and for a further webinar, because I think it is very important to open up these conversations and to have these conversations all over. We do need to think about these things, and I, as a lecturer and a person who's worked in this field for quite a while, there isn't a lot of conversation, and that's exactly why John and I put our heads together, and we thought this was a brilliant topic to take. We need to put it on the table, and we do need to discuss it and put it out there. So without further ado, thank you very, very much for your time. It was all very insightful. I really enjoyed and learned a lot. And I'm going to hand over to Kim then to close off for us. Thank you very much.
Thank you all. What a conversation. Let me close the closet behind me. Cats, closets, things happen. It is my privilege to close today's session and express appreciation. Mr. Stephen Cobb, former Deputy Attorney General of Virginia, distinguished guests, ladies and gentlemen, again, greetings from Attorney General Alliance Africa. I'm Kim Robinson, Country Coordinator based in Johannesburg, South Africa. Our sincere gratitude goes out to the Department of Private Law and IP Law at the University of Pretoria, and Professor Sylvia Papadopoulos, Associate Professor in the Department of Mercantile Law at the University of Pretoria, and from the US, Mr. John Okebu, Senior Staff Attorney, Northeast New Jersey Legal Services. Thank you both for your commitment in putting today's webinar together. We deeply appreciate you. And a big thank you to Stephen Cobb, former Deputy Attorney General of Virginia. Your comments set the tone and provide the context for today's presentations and discussion. We do not take your time for granted. Thank you so much. And special recognition to the AGA Africa leadership, Karen White and Marcus Green. Your vision and commitment have enabled us to both broaden and deepen our footprint on the African continent. Thank you. And the people who provided the content for this webinar. Thank you to the AGA Africa presenters. From the US, Brandon Rutcher, Entertainment and Business Transactional Law Attorney. From Mauritius, Michael AJ, International Business Development Expert. And from South Africa, Jackie Fick, Advocate, former prosecutor and CEO of BizStrat Solutions. Thank you for sharing your expertise with us. And the organizers, the AGA Africa team in Nairobi, Johannesburg, and the US. Your support both before the webinar made the seamless online workshop possible. Thank you for your time and dedication. And ladies and gentlemen, thank you for participating in today's webinar as delegates. I hope that you have found the presentations useful and that the lessons learned will enhance your ability to address e-commerce issues in your daily work. We look forward to facilitating similar events in the future. Because crime does not respect borders, AGA Africa facilitates conversations across borders to address transnational crime. We have a directory of more than 3,000 subject matter experts in various areas of transnational crime. Our facilitators are experienced academics, prosecutors, investigators, and attorneys working throughout Africa and the US. As you experienced in the webinar, the content is practical and can be applied in your work immediately. Our core mandate is to address transnational crime through collaboration and public-private partnerships. There's a crime value chain, and there needs to be a counter to this. At AGA Africa, we strengthen the links of the criminal justice value chain. Will you join us? Our approach is to share best practice from the local context, here, South Africa, throughout Africa, and the US. We don't lecture, we don't instruct. Rather, we facilitate a conversation amongst professionals and across borders to develop skills and relationships to fight crime across borders. Our approach is practical, hands-on, and immediately applicable to the work of prosecutors, investigators, and law enforcement. By training prosecutors, investigators, police, and judicial officers, we build the capacity of law enforcement to deal with cross-border crime. We strengthen the criminal justice value chain to undermine the crime value chain. Through country coordinators in Ghana, Kenya, Malawi, Nigeria, Rwanda, South Africa, Uganda, and Zambia, since 2016, AGA Africa has held dozens of events and trained hundreds of law enforcement and criminal justice professionals. Our training sessions have covered human trafficking, cybercrime, consumer fraud, gender-based violence, money laundering, counterfeit food and drugs, wildlife trafficking, and other crimes. I invite you to visit our website and follow us on social media. AGA Africa looks forward to hearing from you and partnering with you to address transnational crime and improve the delivery of justice for people throughout Africa. Thank you.
Thank you very much, Kim. I just also want to thank John Ukebu, who was also central to getting our speakers on board and to contacting all of you. Thank you very much, Kim.
Thank you all.
And I would like to thank Sylvia, my partner in crime, and Kim for your leadership. Thank you, and I can't forget our wonderful staff on ground that works behind the scenes, putting together these webinars, Norma and co, who don't get enough credits and are deserving of all the credits going their way. Thank you.
Thank you, everyone. Have a good day further, or a good evening further, depending on where you find yourselves. For us here in South Africa, it's evening. It's time to go and make dinner for children. And for Brandon, I'm sure, and Mike, for John, I'm sure there's the rest of a busy day ahead of you. So thank you for joining us so early in your mornings.
Thank you.
Thank you very much.
Thank you very much.
Thank you very much. Have a wonderful afternoon, or morning, or evening. Thank you.
Okay, bye.
Bye.
Take care.